going to go ahead and get started. Hi, Mallory, for our Title Tuesday. So today we have a cool presentation from Peter. Is it Milos or Milos?
Milos, yes.
Milos. And he's the operations manager with Fidelity National Title. And he's going to give us a behind the scenes look at, what does title do when they get that question of, hey, pull a title report. What does all of that look like? So he's going to give us a behind the scenes look. Because this is a meeting, I'm going to be watching everybody. We're going to make sure we keep everybody muted. If you do have questions, go ahead and raise your hand. And you can do that by pressing the chat button. I believe, where is there? Oh, I'm the host, so I don't know where the raise hand button is, but there is a raise hand button. So you can raise your hand to ask a question. And then you can also put your questions in the chat box and we'll make sure to get to everything. So Peter, if you could go ahead and get started. Thank you.
You're welcome, and thank you for having me. And just to clarify, I'm actually the title operations manager for our title department in San Jose. And it's for Fidelity National Title Group, which represents Chicago Title, Fidelity National Title, and Lawyers Title. So I'm sorry, I didn't know if someone was asking me a question there.
Nope, I'm just muting people as they come in.
No problem. So today I thought it would be a great opportunity to kind of share with you all what happens when you request a preliminary report, how we get to that point, and I can discuss some of the procedures and steps that are taken by our team at the title department in order to produce that preliminary report. And then once the report is issued, there may be questions and clarifications necessary, for your clients to understand the effect upon title. And I'm more than welcome to answer questions. And I don't know, I assume you can just use that button as Jody mentioned, or raise your hand or what have you, and then we'll try to address those for you. And I definitely want this to be interactive. I mean, I can sit here and talk to you all day long about title, trust me. It's something I've been doing and just to give you a little history of myself. I've been in the business for about a little over 30 years, I guess. I was a realtor, or actually a real estate agent, becoming a realtor right when I joined the title insurance industry. So that would have been, way back in the late 80s. And it was a whole different time back then. Interest rates were like, 15, 16, 17%. Deals were slim pickings at that time. So that's what got me into title, and I've been here ever since, and I love it. I pretty much held every position in the title department. I started as a entry-level clerk. I've learned to search title. I learned to examine the title. I became a title officer and how to interpret and help people with the closing process. And then I moved into the advisory level, where you really get into the technical stuff. You're able to really dive deep on some of the title issues and discuss those and figure out how to resolve problems to get to a closing. And I was a chief title officer for many years before becoming assistant manager and then ultimately manager of a local Fidelity National Title office. Then we merged our title operations. We realized we didn't need to have title shops in every county and for every brand. So our company merged and placed several title counties and brands together. It just made things more efficient. We're able to produce the reports because we all are part of the same company. So that's why I manage an operation that is not just Chicago Title, it's also Fidelity National Title and Lawyers Title's reports. So when an order is placed into escrow's hands, right? They're asked to open an order and issue a prelim, because everybody wants to know what the title looks like, so that if there's any issues, any concerns, they can be addressed in a timely manner. And so what happens is the moment escrow puts the order into their system, it obviously puts in the property information, the owners, buyers if they're known at that time, the parties to the transaction, applicants, the realtors, lenders, everybody involved. The moment that they complete enough of that order into the system, it generates an automatic order submission, if you will, into the title department. And over the years, things have changed drastically. Where it used to be completely manual, we would actually have to literally take the order sheet off of a fax machine or off of a printer and then run it through our shop. We would take it from that point and run everything. Well, now with the information age, things are a lot more automated. So in fact, we actually have an automation system that the moment the order is placed, within a few minutes of time, the order will actually start. It'll run through an order desk. So what happens, we go out and look for the property tax information and a property chain, which is maintained by a service that we call a joint plant. All counties, all title companies are members of the plant. We share in the cost of maintaining all the records from the county and putting it into basically a computer program so that we're able to abstract the chain of title for a particular property with a few clicks of a button. And it's a lot faster than the old days of having to manually search a title. So that automation process replaces several steps that used to take place within a title department. Individuals would be responsible for running a tax sheet and then running a chain of title and then pulling those documents, running the names of the parties in the transaction to look for any liens against them. All of those steps are now automated. So within about 5 or 10 minutes of an order being opened, theoretically, all of those things, or most of it, is placed into a folder packet for that order so that our searching and exam teams can now finish it and produce the report. Now, some properties will find that we have searched before. We have prior records for that order or for that property, which makes things much simpler in terms of producing the report because we have a starting point, and we actually call that a starter in our industry. So if we have a starter, we don't have to search title all the way back to the beginning. We can actually come from a starting point forward to look for anything new that has recorded since that last title evidence, whether it's a report or a policy that we had issued. And it could have been any one of our brands of title. In other words, with multiple brands and having acquired companies over the years, we have quite a large database of prior starter files. So the good news is most properties that we search, we have some starting point, whether it's 5 years ago, 10 years ago, 20 years ago, what have you, and we don't have to search it back all the way to the beginning of our records. So with that open order process, again, within a few minutes, the order is ready for someone to take it to the next level. Now, some orders are easier than others. If we have a great starting point and there's been no changes, those orders can be processed by a group of folks who are not quite as highly skilled, right? They can take those orders and they can push them out the door for us. So typically those orders will go out within 24 hours or so. Orders that are a little bit more challenging, that require some more back title searching or just some more touch, will take a little longer because someone has to physically manipulate that order and work with, actually search them before they can produce the. And then there's the really challenging orders that we have no title evidence for. If it's not a lot and tract, for example, if it's acreage or section land, those can be very tedious to search the title because you have to go back through the records and locate any information that is on that property that we have in our plant. And then we have to abstract all those old documents and have someone review it and then place it into the file so that the report can be typed up. So, we're going to have anywhere from 1 to 3 days turnaround time in a normal market for our preliminary reports. And that's with that process. Some title, as I said, can be very tedious to search, even if it's a lot and tract, a simple title search. But because of the records that have been recorded, people can really make their title very convoluted and complex by engaging with attorneys that record a lot of deeds for them. Let's say they're planning some estate planning and they start gifting percentages of the property to their children. And let's say that in that process, they inadvertently leave out middle initials of someone in title, or they use an incorrect legal description. All of that documentation, when it's recorded against the property, we have to pull it, review it, and determine, make sense of it basically, so that we can determine who owns the property. At that point, we have to identify anyone that holds an interest in this land, whether it be an owner of record or someone who has an easement right or some other right via a document like CC&Rs. And all of that documentation we have to pull, review, make sure it affects, and then put it into the report for you. So in a nutshell, that's kind of how it works, right? And we take an order and we type a report and we send it out the door. Unfortunately, not every title is the same, right? There's literally, as I was just explaining, what appears to be a simple lot and tract could be very complex. Or on the other side of it, a very complex acreage parcel with a very lengthy legal description could be something very simple because there's only been a few documents recorded over the years and everything is right there in front of you. So, but each one is unique in that regard. And that's why we really don't have an ability to just, for example, people will open the order and then a few days later start asking, where's the report? They're obviously, if they're taking taking offers on the property, they want to have that preliminary report. And in most cases, the reason for any delays is just the sheer volume of orders, right? If we open up a certain number of orders per day, we're staffed to handle that number of orders. But if we start taking on additional orders or more volume, whether it be from, like in our world right now, the interest rates are super low. So the refinance craze began, I guess, well over a couple years ago, and it doesn't seem to have stopped, right? We have a lot of orders for loans. And then in addition, we also service the sale orders. So all that workflow has to travel through our operation. We have in-house folks that do title searching and examining. We have title officers that are there to review the reports and help with the closing. And then we have a myriad of people that are behind the scenes that help with all the different processes. We also use offshore services for a lot of the processes, just because of the fact that it's a lot less expensive than the old days of hiring people and having to do that all in-house. With a lot of the information available as well, it's online, that is, it makes things a lot easier. And we found through the COVID process, once COVID hit, that we are able to do this remotely, working from home, and not having to have everybody there in the office, in the plant, working on those reports. So that's just the overview, if you will, of the what happens behind the scenes and how a prelim is generated. I thought I'd maybe open it up to see if anyone had any specific questions about that process, and we can dive in a little bit more to the any specific questions on that.
If anybody has any questions, you can go ahead and unmute yourself, or you can raise your hand and ask. This is your chance to.
I have a question.
Okay, Julie.
Hi, everybody. I have a question. I've been trying to find out. So I've been hearing these commercials for Title Lock, and I want to know. So my answer, if anybody asks me, or in my head anyway, is why do you need Title Lock if you have title insurance?
And that's a very good question.
And are you familiar with that? So then, if I get the question from a client, I can explain it.
Well, perhaps. So here's what my take on it, because again, I've been hearing those same commercials, right? And it intrigued me when I first heard it, because I actually am a LifeLock member, right? I have that for identity theft, because I actually had a situation personally where someone had tried to open credit in my name, and LifeLock was able to stop that process. And I was, amazed by it. And I thought, wow, this is awesome, right? Everybody should have that.
Right.
So when I heard of the Title Home Lock, or I can't remember the name of the company, but I believe it's something like that, I was intrigued, because I thought, well, they're right, first of all, that fraud is prevalent in our industry. And that's one of the things that title insurance helps protect against, is somebody having fraudulently acquired title and then now dealing with that title, right? So if you're a buyer acquires title through a transaction we've insured, and it's later learned that the seller really wasn't the seller, that they were a fraudster, we're going to make sure your buyer is protected in that situation. And that's what title insurance is for. But it was interesting because that the whole point of title home lock is that it monitors and alerts people if someone tries to steal their title, as it says, right, in the advertisement. So I was thinking about it and I thought, well, how would they do that? So they must have, and first of all, to answer your first question, it's not covered by title insurance because it would be something that happens after the close of our escrow. To understand, so and the difference between title insurance and most other types of insurance, you pay, for example, health insurance, car insurance, life insurance, all those things. You pay a premium monthly, annually, or what have you, to protect you against some future event, something that could occur in the future, right? An accident or health issues, what have you. Whereas title insurance protects you as of the day we close escrow backwards. We're actually insuring against anyone coming forward and attacking the title and claiming an interest in the land. Or, for example, and this has happened in the old days, before recording became prevalent, and that's what it has to be. Recording is the king in our industry. So if a deed is recorded in the official records, that deed is now known to everyone, right? There's a way for people to know that the transfer has occurred. Prior to that, you could actually sell someone a piece of land, give them a deed, and then turn around and do that same deed to 5 other people if you were so inclined, because what's to stop you, right? You can keep selling that land and giving someone a deed in exchange for cash. Now, the idea is under recording, once the recording takes place, so whoever recorded that deed first would have been the record owner of the property. And so that's what we're searching for. We're searching the title to make sure that all interest holders, anyone who has ever given an interest in the land, anyone who has acquired an interest, is identified and that their interest has been dealt with of record. So when a title theft occurs, where somebody records a deed fraudulently, pretending to be someone else, so let's say they forged the deed in your name and deeded it to someone else, some other entity or name, and then they sold the property at that point. If all of that occurred after the close of an escrow that we insured, our title wouldn't protect against that because we've insured up to the date of closing that title was good, that nobody had done that already, in other words. So we couldn't protect against something that happens in the future. I
see that clarifies that for me. Thank you.
Yeah. So that's why when they make that statement, they're true, or it is a correct statement. It's interesting though, because I would imagine they have to run if you sign up with them, they must just have some sort of algorithm, some kind of program that automatically runs and monitors the title records online and looks for any change. So let's say an owner records a deed to their trust. That would probably notify them and they would send an alert to that owner, their member, and say a deed has recorded. It gives an opportunity for someone to, just like with an identity theft situation, to confirm or deny that was them, right? And I understand they offer services to help clear up their title if that's an issue. Honestly, in our industry, we've seen that very thing happen, and our job is to protect against that so if you open escrow and we see some deeds recorded that look out of place, we will actually call out those deeds in our transaction in the report. We're going to require that the party who left title do a deed in front of one of our notaries, you see. So we work to protect against those things for our transactions because we're going to be insuring the parties against any claims or attacks on their title.
So for a homeowner going forward, besides, there's no conventional method of protection?
No, in fact, with the advent of the internet and all this information online as it's advertising that, I mean, I would recommend that myself to folks who are concerned because it's just one extra layer of protection, right? I mean, I look at it this way: most people, because for that to happen, for someone to steal your title like they've advertised and they say, they've gotten evicted from their own home. I mean, I think that's a little extreme. I don't know that it would actually go to that point, because when you learn of somebody committing fraud and trying to steal your title, the first thing you need to do is contact the authorities. You work with them and it becomes an investigation just like any other criminal activity. So, I don't know at that point if a lender or somebody's going to be able to foreclose and take your property, without there being some, some other way of protecting you.
Yeah, I work with seniors that don't have a mortgage anymore.
Right.
So, and seniors that don't have a mortgage and are, they don't pay attention to this stuff. And they don't know, if something happens, they're very unlikely not to respond because they just don't know. So this is my angle is, so if I know, I can teach them and watch out for them. So they can have the tools and the knowledge so that it doesn't happen. Does that make sense?
Absolutely.
That's what I'm asking. Yeah.
I think that's a good idea, like I said, from that standpoint, and for that very reason, offer another service to your clients, right? And be able to explain the difference that, title insurance will protect them up to the day we close escrow. And there are some protections that continue in the new, for example, the ALTA homeowners policy that is the standard policy for most residential transactions.
Right.
That coverage does go beyond the date of the close of escrow. It provides some additional coverages, but not for fraud. I mean, not for somebody stealing your title. I mean, there's no way to protect against something like that.
Okay, so Fidelity or somebody needs to come up with a product. Hello.
I was very surprised when I heard that's not something that we're already doing, right? And it very well could be a service that's added in the future. But
yeah. Okay. Thank you very much. I appreciate it.
You're welcome.
We've got a question in the chat, and then one person raised their hand, and then I'll let you get back to it.
Okay.
A prelim title report shows deed of trust amount is 2 times the listing price, much higher than market value. It is a reverse mortgage probate sale. Do the buyers need to worry?
No. So like anything else, when we search the title, first of all, we're going to report what we find of record. So if a deed of trust is recorded, that happens to be, let's say it's on this face value is $2 million. It's recorded in the official records, and it could have been 5 years ago, 10 years ago, what have you, right? That's not the balance of the loan. That was the original amount of the loan when it was taken out. So that's what's reflected in the prelim. Now, the other factor there is, let's say in this case, the property's worth $1 million. So that would be the double the value thing, right? So that might, lend some or make someone ask the question, why is it over encumbered, or why does it appear to be over encumbered? Well, we don't know what that deed of trust is actually securing. It could be a cross collateralized deed of trust where it secures this particular property and other properties. Or in the case of a reverse mortgage, my understanding is that whatever that face value is it's like a credit line in a sense. That's the maximum amount of the loan that is going to be granted or given. But what is actually dispersed or funded may be completely different. So what's showing on the face value of a deed of trust in a preliminary report shouldn't matter to a buyer anyway, because that loan would be through the escrow process. It's going to get taken care of. It's going to get, before we would be willing to close our deal and insure the title, we need to make sure that the loan's been paid off and that a proper release is going to be either already recorded or will be recorded shortly after closing.
Okay, and then Tracy Tran had her hand up. Tracy, if you'd like to unmute yourself and ask your question.
Yes, hi. So I have a question. So there's people that adding and removing title out of escrow. So let's say a debt, like a family, a dad is trying to add his name to title, and then a few years later they want to sell the property. Now, sometimes when I see that, like when they try to sell the property, it will call like uninsured deed.
Right.
And normally, what does title normally do? Like, let's just say, you know, 2-person on title, and now they're adding another person. So do title like go search for that, the third person, to see if it's like legit, or how does that work?
So that's a very, very good question. So here's what happens. In our industry, we have to be suspicious, if you will, right? On every transaction that happened before. We have to assume that there could be fraud, there could have been forgery, there could have been something untoward, and we need to ensure that that didn't occur. We have to satisfy ourselves and our underwriters that we have taken steps to make sure it's a good title. So when we encounter in the chain of title deeds that are recorded, you know, people coming into title and leaving title, and really for us, it's only when they're leaving title that it concerns us. So if someone comes into title on a deed and they're currently in title, they'll be shown in the vesting. They'll be a party to the transaction. Their interest will be dealt with. It's when we have those uninsured deeds, and what that means is, like you mentioned, you know, they're adding someone to the title or bringing someone in or taking someone off for the purpose of a loan, or you know, maybe just for other reasons that we don't necessarily need to know about. And that's perfectly fine. People can do whatever they wish with their property, right? And transfer title, add people to it. But it's when someone leaves title and the deed was recorded outside of a normal transaction through a title company in what we would consider an insured transaction. So let's say we encounter a deed that was concurrently recorded with a deed of trust. It was recorded by, you know, let's just say ABC Title Company. And we know ABC Title Company is a major title insurer. So we wouldn't be concerned necessarily about that person who left title in that deed that was recorded because it's an insured transaction. They would have taken steps to make sure that the parties executed the deed. It was done in front of their company notary or what have you. But if it was recorded outside of a normal transaction, they just recorded it themselves, or even if they had their attorney record it, it wasn't recorded through a title company, through a transaction that was insured. So that gives us pause. That makes us say, well, people don't give away property for free, right? If it's usually we'll say a gift of love and affection, or maybe it'll have very little transfer tax. But it alerts us to the fact that somebody has given up their interest in the property outside of a normal transaction that would have been vetted or reviewed. So what we ask for is the person who left title to execute an affidavit of or a declaration of uninsured deed. It's for our benefit. It's not recorded in the official records. It's just something we ask them to sign in front of a notary that we've approved, that they did in fact sign that deed, that there wasn't any off-record agreement. They weren't under duress, right? They weren't forced to sign that deed. And then we're okay with it at that point. We realize, okay, that was a valid conveyance of title. Husbands and wives, the spouses, this happens all the time. In a divorce situation, one spouse may deed the property to the other, and it'll even say on the document that it was, you know, relinquishing any community interest in the property. Now, in those situations, they may have left title and it was uninsured, meaning it wasn't through a title company. But in most cases, they may not have an amicable relationship, right? They may not be talking. They may not, once one party signs the deed to the other, they may have kind of washed their hands with it and say, don't ever call me again, right? So it's difficult in those situations to get a deed or an affidavit signed by that person. So what we would accept in lieu of that is if there's a marital settlement agreement as part of their divorce that said this party was to receive the title, that gives us the evidence that we need that person was only executing the deed because of the agreement. And we would accept that agreement in lieu of a declaration or an affidavit. Okay. So that's one of the steps. Now, we usually only look at deeds that are within 2 years. If something's been recorded more than 2 years, it's not likely that we're going to call out the deed for uninsured, because we figured by that time, or most likely within a couple of years, somebody would, if they didn't execute that deed, there would have likely have been something recorded, or they would have disputed it or objected to it in some way.
I see. Another question. So, no, I just want to clarify. You said adding someone to the deed, it's not much of a problem. The problem is removing someone or deeded the house, the property to another person. That's more of a problem. Right.
Because see, if they're adding someone and they're now of record, or on the deed with them, they're going to be named in our report as an owner, right? So their interest is accounted for. It's when somebody comes into title and then leaves title without the benefit of title insurance that we want to ask for that clarification, if you will.
I see. Okay. One more question. So for vesting, husband and wife, so their vesting is just community property. They don't have the word survivorship in it. Now they want to add that survivorship wording to it. Now, without that, if something happened to one of the spouse, it has to be a probate if something happened to the other person?
So that question, it's one of those situations where it really depends upon this. There is, for example, normally when two people are holding title, if they're not in a trust and if they're not joint tenants, if they're just like holding an interest as tenants in common, when one or the other passes, they would have to have their estate probated to be able to take care of whatever interest they held. If it's a joint tenancy or community property with a husband and wife, it's a little different. So joint tenancy is easy because of the right of survivorship. You record an affidavit and it automatically passes to the other. For community property, it depends upon their circumstances, and they would need to talk to an attorney about it, but there's a possibility they could record what's called an affidavit death of spouse, where they can claim under the civil code sections that apply to that it was community, the interest of the parties was community, and that the intent was for the other to receive the title. And it's I know there's some limitations on that. It's something that probably an attorney would have to advise them on, but I have seen that situation where they don't have to go through a full probate. They're able to do it sort of like a streamlined probate because of the community property laws. Now, obviously, they wanted to say community property with right of survivorship or joint tenants in order for that to be the automatic passing of one from one to the other. But at least knowing that even if it just says husband and wife, even if it doesn't say the words community property, if they're able to establish that it was a community or that the property was part of their community, and again, their attorneys would be able to advise on that, they should be able to use the declaration affidavit death of spouse that says that they've met the criteria for that to pass. And I know one of the criteria is they have to have been deceased for more than 40 days. I believe they have to have had a will, and it had to have said that the spouse was to get the property. There's some format for that.
Thank you so much, Peter.
You're welcome.
And I don't know if this is on the same topic, but can you give an example of maybe a file that didn't close and why maybe that wouldn't have closed?
Yeah, it doesn't happen that often. Most situations that arise, right? We call them, underwriting issues, basically. If it's something that we encounter in our title search that creates some cloud on the title or some issue that prevents us from, and again, to clarify, as long as somebody is willing to take subject to, in other words, if they take title subject to the matters that are shown in our report, for example, we're going to show the easements, the restrictions, the liens, any clouds or defects that we encounter will be shown in the report. So if the party is willing to take title subject to those items, there's no reason not to close. In other words, we would be able to close, issue their policy, and their title is subject to those matters. Most people, though, are going to want clear title, right? They're going to want, they know that easements and restrictions are not going to be able to be removed because those are usually forever, like an easement, for example, is perpetual, unless it's relinquished of record, it stays on the property. CC&Rs could expire after a period of time, but typically those are going to last, most, if not forever, certainly for a lot longer than most of us will be around. So it's when there's something insurmountable, some issue that the buyer is not willing to accept. Let's say, and this happens, a seller opens an order, we run the title, and we find that in the title search there were parties in the chain of title, historically, that didn't deed their interest out. For example, let's say there was a husband and wife in title, one had passed, and all of a sudden there's a deed from just the one spouse to the next party in line. Well, what happened to that other spouse? So it may be a situation where they say, they were holding title without any specific status. It didn't say joint tenancy. It didn't say community property. So we would require that person's interest be dealt with. If that never had been dealt with, they may have to open a probate. It could be very, just lengthy. It may be something costly that prevents them from doing it, or just they can't find that person and they don't want to go through a quiet title action through court to remove that person's interest. That would be a situation where we can't close an escrow at that point if the parties aren't willing to take title subject to it. Lenders certainly aren't going to loan money on a defect on title, right? That's if it's going to impact their interest. So, but it's very rare for us to decline a transaction. In other words, where we say we won't insure this transaction. And honestly, when we do have a situation, and I'd say it's only happened a handful of times that I can think of, it's for reasons that we really can't disclose. In other words, we found something, whether we believe there may have been fraud, or maybe the party that was someone in the title or who opened the order had some prior history with our company, either in a claim situation or are known to have had some issues. It may cause it's a red flag situation for us. And we may just say, we politely decline to insure this transaction. We can't divulge or to go into any details of those situations. But usually when an escrow can't close or it fails to close is because the parties just can't come together on whatever the issue is that was uncovered. Did that answer the question for you?
Yes.
Okay.
And I'm going to put a link in the chat box real quick. You've talked about how title is, how deeds are titled and how to do that. And we did a webinar in February, actually, with a few attorneys that talked about how to title, because I understand that you guys can't give recommendations on that and real estate agents can't give recommendations on that. So I'll go ahead and put the link to that so that you guys can go ahead and listen if you'd like to on how to hold title. So if you want to continue on, I'll put that in there for anybody who wants to watch that at a later time.
Yeah, because that's important stuff, because it can all have ramifications on taxes, and that's the other thing. Like a lot of times people will record their deeds without a transfer tax because they don't want to pay tax, right? No one wants to pay it if they don't have to. So they'll usually try to put like a gift of love and affection on the deed and record that, for refinance purposes, right? They're just trying to get someone on title or off title, and they'll use that verbiage on a deed. I've had attorneys that have told us before that, you should caution your folks on that. Of course, we can't, because we can't advise, but that could have impact on, that could be viewed as a gift, right? And there could be taxation on that. So that, there's all kinds of ramifications when it comes to title, and that's why we can't get into that advising on, you should hold title as joint tenants or community property or right of survivorship. There's so many different ways of holding title, and it really depends upon the person's situation, their circumstances, as to what fits best for them.
We have another hand raised. Are you okay with just going through questions? Does that work for you?
Absolutely.
Okay.
Yep.
Joseph has a question. Joseph?
Hey, Joseph.
Yeah. Hi. So as far as the gift, isn't it true that if a parent is gifting something to the child, the tax consequences are not, they won't get taxed right away. It's just added to the amount that they've gifted, and at the end it's taxed. So they're up to $1 million. It's documented, and then at the end if they when they pass away, then the tax consequences they become realized?
Yeah, that's hard for us to really get into because it's more of a legal thing, as far as the gifting and the percentages. But I know from the standpoint of exempt, property taxes, if you will, because that's been a big issue. So when a parent transfers to a child or a grandparent to a child, there was exclusions that you could apply for at the assessor's office that allowed the property tax base to be passed to the child, right? If you've owned the property for 50 years and now you're going to give it to your children, you could pass the deed or record the deed to them, and it would be excluded from reappraisal by I think it was Prop 60 or one of the propositions. And that had been in place for a long time, and people were able to take advantage of that. Well, then earlier this year, after last year's election, there was a law or a proposition that was passed that didn't get a whole lot of cover, I guess, on the ramifications. In other words, people didn't realize when they were voting for what sounded like a really good, I guess a bill or legislative bill, that it was a good thing. Well, it turned out, I can't remember the name of the prop now. It was back in February. February 16th is when that date occurred. But so with the passage of that proposition last year, I believe it was February 16th of this year, any deed recorded after February 16th from a parent to a child is now subject to reappraisal. So where you used to be able to exempt and keep the same tax base, now the moment the deed is transferred or a deed is recorded, transferring title to the child, they can't claim that exclusion anymore, and it's reappraised and reassessed at the market value, which has very serious ramifications.
That's actually Prop 19.
There you go. Yeah.
If the child takes the possession of the property and lives in it, the taxes remain the same. But if they want to turn around and rent it, then the taxes will change.
Exactly. There's limitations, and I know that I've heard that there's been some follow-up legislation, if you will, that's trying to be pushed through to amend that aspect of it, because it's impacting some people, right?
Yeah, but that's at the time when the parents pass away and the children's inherited. But I'm asking about when the parents are alive and they gift a property. Are they taxed on the same year, the year after, or they're taxed at the end?
Yeah, that's more of a question for a tax attorney or someone in that regard, because that's not something we get into in title, unfortunately. So I couldn't really respond to that one.
Okay, but you guys notify IRS when things like this happen, yeah?
I know that there are requirements for us to report to the IRS. I think that, Marlene, that's probably the 1099 process, right? Is that what escrow does? I'm not sure if she heard me.
There it is.
Yeah, there you
go. Yeah, that's 1099. And then also that SB, there's another form, tax form that has to be reported as well. That we do anyway.
Yeah, and my understanding is, like when you gift, most gift planning or gift, when they gift, we'll see, at least when we search the title, we'll see a number of deeds recorded over a period of years, like one every year for several years, where they're gifting percentages, small fractional interest in the land. And that has to do something with those gift estate laws and the tax laws, that they're able to do a certain amount per year to avoid taxation.
Yeah.
Yeah, we just see the effect of those deeds, right? We don't actually, know why they're doing it that way, or
because I think, I don't know how much it is, the amount of it, but every year you can give a certain amount of money to your children and not be taxed.
Right, and that's probably why we see those. Yeah, because a lot of times it's very small percentages, and that's where it gets very interesting. So from a title perspective, we search the records, and we'll find where people will use fractional interest. They'll use percentages to a property that's been in a family for years and years, and then as someone passes, their decree of distribution says it goes to their children or grandchildren, and they distribute it using everyone gets a 1/5 interest. Well, that may be a 1/5 interest in that person's 1/4 interest or what have you. See, so it gets very complex to try to figure out what that actual ownership percentage is now. In some cases, what we have to do is we'll list every person we believe that has an interest, even if we don't know what that interest is, but that we're going to require that they execute a deed or be a part of the deed to the buyer because we feel that they have an interest by what we've searched in the records in that situation. So,
got it.
Was there any other specific questions?
No other specific questions who have come in. We've got about 15 minutes left. I've got some if you just want me to ask some questions, or Marlene, if you've got some things. I was seeing maybe red flags. What are some red flags that come through on title, or what are things that shock people when they're going through prelims? Like, what do you see most often?
Give
Marlene?
us some stories, Peter.
Yeah.
Well, yeah, I mean, I can try to share some of those with you. So, I guess, red flags, right? Some of the most prevalent things we see are unreleased deeds of trust. Okay, so that's big. What happens is your owner, you've got a listing and you're working with the seller, and we know that they've got one loan on the property. The preliminary report comes out and it shows 3 loans on the property. The one that you expect, and then maybe a couple others that are older. So what happens is when we search the title, we obviously are looking for all open liens that affect the property. And if there's been a mortgage recorded, and then let's say a few years later, we see another one recorded for the same amount, a very similar amount, might even be the same lender, it's pretty clear that that was a refinance, right? They refinanced. The idea was they're paying off the old mortgage and getting a new one. Well, through the processes, that old one didn't get released of record. It's still showing of record. And some years later, they may have done 2 other refinances, and then it happened again. Another loan that should have been released of record was not. So now we come down to a report is open, or I'm sorry, an order is open, a report's generated, and we will show not only that new lien, but those 2 prior liens, because our search did not detect a release or a reconveyance of that deed of trust. Now, people will throw out, well, it's clear that that was a refinance. You've seen that, the new lender wouldn't have taken subject to those other loans, and all that stuff is true. But the moment a deed of trust records in the official records with a securing the property, as collateral for that loan, it is a lien upon that property. And California law states that that lien will remain for 60 years from the date it's recorded, or until it's released of record by a reconveyance, or it can be ignored 10 years after its stated termination date. Now, most mortgages and most institutional lender loans do not have a termination date. It's just shows the full amount of the loan and all the parties, and it gets recorded. So when we encounter that situation, obviously somebody points out those 2 prior loans should not be there. They should have been paid off long ago. Well, the first thing we do is we go back and double check. Maybe we missed the release in our search. It happens. When human beings are involved in all of this process, people make mistakes, right? So the first thing we do is a check to make sure that we didn't miss a release. It's very possible, and it happens also, the document releasing the lien could have been posted to some other property. But through a grantor-grantee search or other ways of us searching, we can at least try to determine or rule that out, if you will. If at that point we can't find a release, and it is required for us to insure over that lien, because, for example, the buyer doesn't want to take title, and then let's say if we know that those liens were paid and we just chose to ignore them, we just said, okay, those were clearly paid off, we'll just ignore them. We could do that if we chose to, but then the buyer who gets title and receives a policy not free of those liens, the next time they go to open a title report somewhere, it's likely those liens are going to come up again, and they're going to get shown in their report, and then they're going to come to us saying, hey, why are these liens that were cleared in the escrow showing up again? So at that point, we can say, well, we'll insure you again, right? Come to us and we'll insure your transaction. But what if they don't want to come to us? What if they want to be able to go to any title company? it's their right to have clear title, and the seller is obligated to provide clear title according to the contract. So we have to take steps to get those liens off of the record so that the buyer's title is clear. Now, sometimes those lenders have gone out of business and they can't be located to get a release. So there are other options. One of them is if a title company, if an escrow paid that loan off and there's evidence of that payoff, meaning copy of a check or a wire or something, then there's a process where it's a document called a release of obligation. It's equivalent to a reconveyance. Title company can prepare that and record it in the records. And it is basically, like I said, it's equal to a reconveyance. So when the liens are shown in the report and you don't expect them to be there, it's imperative to have escrow, talk to escrow, talk to the clients, start working on it. What we found a lot of times, those lenders did send the release of that loan to the homeowner, and it just didn't get recorded in the official records. So if they go through their paperwork, they might find that they actually have that original release sitting in their safe or wherever they keep their records. And there's been many times where our escrow officer has been able to help them, look for that stuff and bring it in and have it recorded. The other option is obviously contacting the lender and getting a release of record, a release or reconveyance to record. Sometimes it's just not possible. The lender's out of business, they don't have records. So there's a surety bond process where they can purchase a bond that the bonding company does a process where they record notices. They send out notices to anyone who was on that deed of trust as to, if you have an interest in this land still, let us know within 10 days or 30 days, I believe it is. And then they're going to basically terminate that loan at that point. They record a release. So those are some of the options for getting that old deed of trust removed. Sometimes though, and Marlene, you probably seen it on the escrow side, where they've exhausted all efforts. They're just not able to locate any of the past parties. If a bonding company is not willing to issue a bond for that particular note, or they just can't locate anybody, then they might have to do a legal action to get that removed. Title companies are often asked, can't you just remove it? It's been paid. And it's not about the monetary part of it. We can see and tell, that it's not likely that there's any money owed on that the lender was in fact paid off. But because the lien remains on the title, it puts us in that position of how do we offer clear title to a buyer, knowing that lien could still pop up in the future. So those are just some of the things that we see, the red flags.
I think a lot of those popped up was 2007 and 8 with Countrywide, Washington Mutual.
Yeah. We've got a pretty good system going where, escrow knows which lenders are more problematic and others is trying to get releases from, because lenders have been taken over by other companies, and, then their record keeping isn't the greatest. And it does put a lot of burden on people, to try to clear these when they're trying to close an escrow. So that's why, again, it's crucial when you get the preliminary report, review that with your client, go through it, and make sure there's no surprises. You can ask escrow to kind of review it with you, and they know from their expertise if something looks like it might be troublesome to get handled before closing. So
I'm going to put another link in the chat. That is to our Title Tuesday from March, and that was how to read the preliminary report. So I'll put that in there as another resource if anybody wants to watch that one as well. Do you have any final thoughts? Anybody have any final questions for Peter while we have him in here about the title process? I imagine this big room with a bunch of just titles and deeds sitting in it, and somebody goes and kind of finds them and brings them back. Is it all digital? Yeah,
it is. We're one of the only title companies still local in terms of, we have a San Jose office and we have a full title plant. So we have a back room that is full of books. And when you walk in there, you get that dusty, musty old smell of like an old library, right? When you walk in, it's Marlene, you've seen it. We've had folks come into the plant and take tours before. It's very interesting. And we do use those books on a regular basis. They're old account books that have handwritten entries from people who used to copy the records from the county into our own book so that we could maintain and have this information available. The way that we used to search title would be, literally going to those books or going over to the county records and abstracting everything by hand and then pulling the documents and doing it. Now, with automation, everything that happens behind the scenes for us pretty quickly, and the fact that most properties have been insured multiple times over and over, it's a good chance that we're going to find one of our companies has done so in the past. So we have a good starting point, like I was talking about in the beginning. But we do still have to use those books on a regular basis. We've imaged it, we've copied it. So in the case of a fire or something, devastating, we would have access to it. But unfortunately, it's not quite fully online yet. We haven't got it to a point where somebody could, like all this past year plus, I've been working from home, and I do a lot of searches, those backplant searches, and I was able to do quite a few of them from my computer here at home, at home. So it's doable, but for the most part, you have to have those books. You have to have the key maps that go with it. So every property is indexed within there in some way, and everything came out of something bigger, which came out of something bigger, all the way back to the patents in the 1800s. So
that was my question for you: is how far back does this go? So it sounds like it goes back. Now, does every address have like its own little card, and it's like a record of everybody who's
kind of. It's like, well, we have these big books, and they're basically, I don't know how big they are. They're they're huge. They're really big books, and each one is an account for like a subdivision, if you will, or an area. And the lot and tract, the ones that have all been subdivided, where you have a tract of homes, those are easy because, we have that starting point. It's been mapped. Everything's on the map, right? Easements and all the documents. So we have that account book, and then every lot in every subdivision is within that book. The acreage parcels and parcels that came out of something else gets a little bit more tedious to search because we may have to open 3 or 4 books to get the full history of title. And it's when you're searching backwards in time. So you start with who owns it today, and we're working ourselves backwards until we get to the original transactions. And it's interesting. It's stuff people usually get blown away by it when they come in and take a plant tour.
Yeah. And so you just talked about a plant tour. Do you guys, in a non-COVID world, do you offer plant tours?
Yeah, prior to COVID, we were definitely doing that. And I'm sure we will again. Once this is all back to normal, we'll be able to do that again for sure.
Okay. Maybe we'll set something up later in the year if maybe on the Title Tuesday, we'll see how many people would be interested. I'd love to see it.
Yeah. It'd be very informative. We usually had, when people come in, it's like, you can tell I can kind of tell, okay, that would be a great title person because they're so fascinated by this stuff, right? It's interesting. And that's what it really has to pique your interest. You have to know, or kind of understand it to really be able to do it well. So
okay, well, Julie's in, so we got Julie and I are going on a field trip later this year. It sounds like so. We'll keep connected, and especially with Marlene, and maybe we'll plan something to come down and see it and get some more questions and answers. So Peter, I want to thank you so much, and thank you, Marlene, for helping get this set up. So we did record this if anybody wants to